Ready for the dictation? 5 seconds to go. Start. This appeal has been preferred against the judgment of the learned single judge, holding that the services of the workman will be deemed to have been terminated on the day when the action of the management was upheld by the Labour Court. Stop. The learned single judge, while concluding as above, relied upon Desh Raj versus Industrial Tribunal Lucknow. Stop. Aggrieved by the said judgment, this appeal was preferred by the management, inter alia, praying that the finding of the learned judge was contrary to the constitutional bench. Kalyani versus Miss Air France AIR 1963 SC 1756 to the judgments of the Punjab and Haryana High Court, which were rendered prior to the impugned judgment. Stop. The learned single judge has awarded back wages from the date of dismissal, that is, acceptance of the resignation of the workman from 27/3/1970 till the Labour Court upheld the dismissal on 8/4/1992, and it is this grant of back wages to the workman which has been assailed before us in this appeal by the management. Stop. Next para. The main thrust of the argument of the learned counsel for the appellant is that the date of dismissal, which has been observed by the learned single judge, could not relate back to the date of the order passed by the management, and termination or acceptance of resignation was contrary to the dictum laid down by the constitutional bench of the Supreme Court, as well as other authorities passed by the Supreme Court in this regard, including a recent one in Punjab Dairy Development Corporation Limited. Stop. The Supreme Court specifically overruled Desh Raj Gupta's judgment. Stop. When the appeal was filed on 31/3/1997, notice of motion was issued and the impugned order was stayed. Stop. Thereafter, the respondents did not appear in the appeal. Stop. Next para. A statement was made on 22/9/2006 that a fresh application will be moved by the appellant for substituted service, as it was not possible for the appellant to serve the respondents in ordinary manner. Stop. Thereafter, the court directed the publication of notice in the newspaper, which has since been made in the Tribune on 12/3/2007, but despite that, nobody has put in appearance on behalf of the respondents. Stop. We have heard the submissions of the Learned Counsel for the appellant. Stop. The finding of the learned single judge that the services of the workman will be deemed to have been terminated. Stop and over.